Carol very much. Always wonderful to be introduced by you. My name is Karen Schaffer. I'm a member of the Roseville Area League. I've been a member for many, many decades. I'll keep the numbers secret. There's sort of two motivations behind this program. The League of Women Voters of the United States, or as I call that group, the mothership. They are doing a study on the Federal Judiciary, and we will have, as League members, the opportunity to vote on some questions. What position should the League of Women Voters US take? And to do that, we, as Carol said, we study and we read up, and then we can answer questions. So if you're not a member of the League, you could, and you want to vote on those questions, you could become a member of the League. And the other thing is, last month we did have a program on the state judiciary. So, having one on the federal judiciary, that, seemed pretty logical. So, yes, I will be happy to take questions. I'll answer any that I can. And the ones I don't know, I'll just say I don't know. All right. Okay, Rita, I don't know, the arrow's not working. We tried it before.
Karen, what's your legal background? Just make it, sorry.
Okay, so I already have a question. So the question is, what is my legal background? I am a retired attorney. I'm a retired government attorney. I worked in Dakota County Attorney's Office, and I worked at the Metropolitan Council. So I'm sort of a government geek. I am a nerdy mom. When I drove my kids around, when you got the downtime between daycare and whatever, we always discussed the three branches of government. Who is the governor? And so they always knew who their local rep was and who the senator was or whatever. So we did it state and federal. So when Rita and I and Carol talked about this program, this is where I start, right here. My sad little worn out copy of the Constitution. The system we're talking about today is Article 3, the judicial branch as it is set forth in Article 3 of the Constitution. And the first thing you notice when you look at Article 3 and you compare it to Article 1, for example, or Article 2, you notice that it's minuscule, it's teeny weeny. It just doesn't even take a page. Whereas the founding fathers, and they were all fathers, the founders, they went on and on and on about Article 1, the congressional branch. They went pages and pages and pages, what they can do, because that was, their concern. They knew they wanted one Supreme Court. Because the 13 states, 13 Supreme Courts, what could go wrong? So they knew they wanted a Supreme Court, but they could not agree on anything else. And so at the end of the convention, they just punted and said, well, Congress can go figure it out later. So the article is short. It says there's going to be one Supreme Court. It's going to be inferior courts established by Congress. Inferior is as a term of art. It's old-fashioned. It just means not supreme. They're not actually morally inferior or legally inferior. They're just lower on the pecking order. The judges hold office during good behavior. So that's basically life tenure, unless, of course, every once in a while it's happened, a judge has been impeached, impeached by the House and tried by the Senate. It's very rare. These judges, they have to be paid, and you can't give them a pay cut when they're on the bench, which it turns out is it has some interesting consequences. But this is the whole thing. This is the who. Who are these people? Now the next question, what the heck do they do? First one, they exercise judicial power, which means they don't do political power. They don't exercise political power. They're supposed to decide cases where the parties are at odds and they're going to exercise judicial power. The founders did list the types of cases that would be within their wheelhouse. Any case under the Constitution, a case arising under federal law or under a treaty, admiralty and maritime. Of course, the high seas were a big deal in, the 1700s. So there was a fair amount of admiralty and maritime disputes that needed some court to have jurisdiction to fix it or solve it or resolve it. Any case where the U.S. is a party, a case where there's two states suing each other. You can't give it to state A, you can't give it to state B, you gotta give it to somebody else. Or controversies between citizens of different states. So this is sort of what the founders said, the courts, the Supreme Court, and whatever other courts Congress came up with, this is the subject matter that they are entitled to take up. And there's two other provisions. One is called original jurisdiction. This means these cases, the Supreme Court is the first stop. So if there's ever some problem with an ambassador, frankly, I don't know if it's ever even happened. But you just go to the Supreme Court. You don't go to a lower court and then appeal and go up. So that's original jurisdiction, or where a state is a party. The rest of it is appellate. So the founders knew Congress would set up some extra courts. Appellate means you hear it from appeal. And so Congress could establish inferior courts, and then the Supreme Court could have appellate jurisdiction. Whatever appellate jurisdiction Congress felt like giving to them. So we have the who, we have the what, now we've got the branch problem. Article 2 of the Constitution, that's the executive branch. You might have been noticing some executive branch activity the past 2 weeks. But the only thing that the executive branch has to do with the judicial branch is the executive nominates and appoints the judges for the courts that Congress establishes. And then there is the advice and consent of the Senate. And maybe everybody in this room, we've seen that process. It used to be that it was so uneventful that there were no hearings, used to be no hearings. The judge candidate, the nominee, wouldn't show up, no need, and they would vote him in, historically him, but increasingly her. They would vote on them, 98-0, because 2 people were away. They just sailed through, and it was so uneventful. It was just done by, paperwork. Now, between Congress and the judicial branch, there is a much, much more heavy-duty connection. So Congress can establish the lower courts. The Senate gives the advice and consent for judges. Congress sets the budget. And so that's why eventually they got the Supreme Court building in 26, Congress said, well, you know, we think there should be a Supreme Court building. And they included in a big capital project bill the money to start building what we think of. We know the Supreme Court, we've seen the pictures. Many of us have walked those steps, but they didn't have that until 1936. Before that, you know, they would meet in the Capitol, they worked at home, you know, they did telework, but there was no internet, so they had messengers running back and forth from their home or to the Capitol. The House could impeach any judge for bad behavior, not high crimes and misdemeanor like under the executive, but just bad behavior. And there's been a few impeachments of some lower court judges, you know, there's always gonna be a few bad apples. And then Congress can make, you know, whatever laws it wants to kind of support this activity. So Congress got right to work, right in 1789, right out of the gate. And they said, we're gonna have 6 justices on the Supreme Court. Because the Constitution didn't say how many, so they picked 6. And they picked 3 circuit courts. That would be kind of an appellate court. And there were 3 circuits, the North, the Middle, and the South. And then they had 15 district courts. Now that's the judge who first gets the case. We think of it as the trial judge. It may or may not have a jury, not necessarily, because there might not be a criminal case, but they had 13 for they had 15, and that included at least 1 in each state. And maybe 2 of them had 2. And they gave the Supreme Court appellate jurisdiction to hear cases coming up, first the district court, and then the Court of Appeals, and then maybe the Supreme Court would have the right to hear it. Now, the odd thing was they didn't appoint any judges for the circuit courts. So there's a trial, you know, in the trial court, the district court judge trial, and declares somebody a winner in the lawsuit. And then there's an appeal, but there's no assigned judge. So what the Supreme Court justices themselves, they had to be the circuit court judges, and they had to ride the circuit. They had to go, literally. 2 of them were assigned to the north, and 2 in the middle, and 2 in the south. And they had to go and be the Circuit Court of Appeals. And they had to ride, and it was not easy. No roads, no railroads, you know, no phone, no internet. So it was a hard job to be a Supreme Court justice. You know, we think of them as sitting in that palatial building in Washington. They had to get on their horses and ride. So today, sometime earlier last century, they decided on 9. One time it was 10. Now there's circuit courts of appeal, there's 12. And 1 more for the Federal Circuit. And they have their own judges assigned. So the Supreme Court doesn't have to ride circuit anymore. And there are 94 district courts. 1 or more in each of the states. There's 1 in District of Columbia. Our possessions, you know, Virgin Islands, Puerto Rico, Guam, North Marianas, there's a district court there. There isn't one in Samoa. If you have a lawsuit and you live in Samoa, you have a federal case, you have to go to the Northern Marianas. And there's 2 specialized trial courts for certain kinds of commercial transactions. So in Minnesota is one judicial district. It's just called the District of Minnesota. Texas, on the other hand, I think has 5, because that's big. Florida has 4 or 5. And who is our Circuit Court of Appeals? If you have a trial in one of the 3 courthouses here, and one in St. Paul, one in Minneapolis, and one up in Duluth, and you want to appeal your case to the Circuit Court, we are part of the 8th Circuit. And that includes the Dakotas, Nebraska, Iowa, Missouri, and Arkansas. Today it's a very conservative bench. So, the Judiciary Act of 1925. This was a hugely, hugely important law. Now, you can see the courts were started in 1789, and now we're up to 1925. Before 1925, the Supreme Court had to take every single case that was appealed from a circuit court. So there were hundreds of cases. So they were not only writing, they had to take every case that came, even the boring ones, even the ones that affected just 2 people and no money. They had a river of cases. And Chief Justice Taft, who I think he wanted to be Supreme Court Chief Justice more than he wanted to be president, he knew that he wanted the court to have control over its docket. And so he was one of the forces behind what historians call the Judge's Bill. And under that bill, which became law, the Supreme Court has the power to choose which cases it will take. Pick and choose. So you can just say, like Nancy Reagan said, just say no and don't take it. And that sliced away a huge, huge volume of work. So they got there, and in 1936 they got their building. Now they have 4 clerks apiece. They don't have to ride circuit, and they can pick and choose their cases. So it became kind of a fancy job. And this quote here, the justices were transformed from passive recipients to active participants in the making of the law. They only picked the cases they felt like working on, just in their own opinion. And there's no law that says how many justices have to vote to take a case. The practice is 4, usually. But they'll pick, and we know that they do pick certain subject areas that they're very interested in, and others let that circuit court of opinion, close enough. Now, if this slide had been shown to Justice Alito, he would have said, that is bad. That is rude. We have the Supreme Court now, they have their docket, what they're going to do, which cases. And there's 2 branches of that now. One is now called the merit docket. Now, those are the cases the Supreme Court says, we are going to take that case. And you read about it in the paper. They're going to take the case, when the briefs are due, it's going to be argued. You can even, at least during the pandemic, you could listen to the arguments, and that they were going to write a big opinion, and maybe 4 opinions, who knows? You know, it's a big deal. And that's what we call the merit docket. And I want to check one number. For 2022 to 2023 was 58 cases. Whoops. So then we have the shadow docket. The shadow docket is a negative term, and that's why Justice Alito would be very unhappy with me for being so negative. It's sort of becoming a little bit mainstream. People, until last year, no Supreme Court justice had ever been heard saying it. But I think that Sotomayor, she might have actually used the phrase. So it's sort of creeping into everyday parlance, but it means sort of 2 things. First of all, there's no arguments. There's no oral arguments. There may not even be any briefs. And you can imagine a merit case. This is what happens on a merit case. They have a trial in the district court. And in the old days when they were paper records, you know, they would have boxes, all the exhibits, all the testimony, all the lawyers' briefs and memos. And then it'll go to the Circuit Court of Appeals, and there will be another layer of briefs and arguments. And then the Supreme Court gets this enormous case, and they make their decision. Now, on the shadow docket, these things, typically they're emergencies. They're usually unsigned. You don't know who wrote it or who's for it or whatever. Now, emergency, I mean, the fact that there are emergencies is not the shocking fact. I mean, there's going to be stuff happens, and maybe you just have to act quickly. Even the Supreme Court, we'll start to see probably some of that coming with, we've got a lot of district court cases now with temporary injunctions. Those will creep up through the circuit court and maybe, and I do have some examples of this. So the fact that there's an emergency isn't inherently wrong. You know, what if the parties need more time for their briefs? Or what if somebody's changed their lawyer and then somebody, you have a bunch of paperwork, There's a lot of procedural stuff. But when you add this together with the fact that they pick and choose what they're going to take, they're the only ones who decide what's an emergency. And there used to be, and there still is a lot of law making it hard to get in federal court, but they've been transforming that. And they pick and choose more by topic as opposed to the nature of the emergency. So I'll give you an example of a shadow docket case, of which in 20 through 21, there were 5,000. So there's a lot of unsigned orders, and a lot of them don't make a hill of beans bit of difference. But a few of them have a lot of impact of what happens on the ground. So you'll remember the Texas Heartbeat Act. Still in effect today, basically eliminated the right to abortion and privatized the prosecution of abortion cases. They can be brought by anybody who knows anybody who had an abortion. You can sort of like a privatized, it's sort of vigilante type of prosecution. So Texas put that law on the books. This is all before they got rid of Roe v. Wade. So even though the federal law says there is a right to an abortion under certain parameters, Texas went ahead and passed the heartbeat law. So the providers, well, they ran right over to the district court saying, they can't do this. This is unconstitutional. So the district court set a hearing for the day before the law was to take effect. This all happened, in a couple days. The state, one of the defendants went to the Fifth Circuit, which is where Texans go for appeal from the district court. We go to the Eighth, they go to the Fifth. So they went to the Fifth Circuit, which entered a stay. They said, everything is halted. All right? On September 1st, the law went into effect. Since there was no court case, no order, nothing to stop it, the Supreme Court on that day issued a 1-paragraph opinion, a ruling, agreeing with the Fifth Circuit that all proceedings were stayed, which means that the Texas Heartbeat Act is in effect. 1 paragraph. Okie dokie, giving the okie dokie to a state statute, which was deliberately and completely at odds with current Supreme Court doctrine. That's the shadow docket. Now, there were also 5 vaccine mandate cases during the pandemic. Different places, different entities saying, well, you have to have a COVID vaccination, for the military or for wherever. And they made 5 shadow docket decisions refusing to block them. In other words, they let the vaccine mandates stand, which is a big deal. But there were no briefs or anything. Harvest Rock v. Newsom. This is a case out of California. It was about the COVID regulation in California that, remember, we had them here. You can't have too many people together in a room. And so a lot of the litigation came from churches saying, now wait a minute. The freedom of religion, we have the right to, we have that constitutional right. So this case, a church, Harvest Rock, sued Governor Newsom of California. And the district court said, that the statute was bad, regulation was bad, and issued some kind of injunction. And then the Court of Appeals agreed, and then the Supreme Court they got it, and they issued an unsigned emergency order tearing down the California rules that applied to churches. So all of a sudden, the churches can do whatever they wish. Maybe that's the right decision. You know, that could be correct under the law. It's not inherently shocking, but there's no opinion. You know, no opinion. Like, what's the reasoning? You know, and so that's why the word shadow is used, because they make these decisions. They could have a lot of effect on people or institutions, but since they don't put anything in writing hardly, who knows, you know, what's the law going forward? You know, a lot of states would have said, well, if you had a big opinion, how far can you go on restricting churches? You know, what's the standard? What's the rule? What's the reasoning? It's just, you know, just a black box. So that's why you get a book like this. It's just called The Shadow Docket. And it's a little bit of a polemic, but it's kind of interesting. You have to be a little careful. Okay. So that's what the court is and who the judges are. Now the question is how do they do their work? And this is an area that the League of Women Voters of the U.S. has indicated is something that the league should have a position on. So there is a code of conduct for U.S. judges. It's a set of guidelines based on integrity, independence, diligence, impartiality, extrajudicial activity, avoiding impropriety, and the appearance of impropriety. So where did this ethics rules come from? They came from the Judicial Conference of the United States, which is a bunch of federal judges. And they apply to all judges in the federal system. All the Article III judges, except the Supreme Court. So this is, you know, it's a big committee, you know. The judicial branch is like any branch of anything, you know. You have to have committees, writing policies and looking into stuff. The main committee is the Chief Justice, that'd be Roberts, the chief of each of the 13 circuits, and one district court judge from each circuit. So there's 66 circuits, or 66 districts, you know, about 700 judges. So there's a bunch of just judges, and they have staff, and they have offices, and an IT department and everything. Now here's the curious thing. Why did they decide to have the Judicial Conference of the United States? Well, Congress told them to do it. They said, you should have a committee that's going to look into these things. And so they said, all right, so they did. There's no enforcement mechanism in particular, because remember, no matter how bad a district court judge is, stupid, lazy, ignorant, partial, criminal, asleep, no matter how bad, there's only one way to get them out of their job, and that is to have the House of Representatives impeach for bad behavior. And it's another, and since you can't cut their pay during their term on the bench, you basically means you can't fine anybody, because that would amount to a cut in pay. So they are completely insulated. Now, that being said, if you know any federal judges, or if you've appeared in any in the state of Minnesota, they are great. Typically, they are great. And they would never they don't do untoward things. So these are the basic ethics rules. You're supposed to uphold the integrity and independence of the judiciary, avoid impropriety, be fair, impartial, diligent. Watch out for what you're doing when you're not on the bench. You can't be really run for office, which is a complete switch from the beginning. In the very beginning, you know, when they went to appoint the first 6 people, you couldn't say, well, we want people with judicial experience. Well, there weren't any. They were all politicians. And that's how the first appointments went, you know, for the first 100 years. Now, the Supreme Court, they have been under attack by in some circles for not having a code of conduct. So they adopted one. And it's really, when you read it, it's a lot like the other one. You know, I mean, judicial codes of conduct aren't, you know, by definition, they're not that different. It does include the duty to sit, you know. If you had too many Supreme Court justices recusing them from sitting, you know, you might get a case decided, you know, 3-1 or something like that. That would threaten the legitimacy. But there's no enforcement. There's no committee, or the Chief Justice has no particular authority. So when a Supreme Court justice, you know, has a private telephone call with the executive branch, you know, before a decision comes out, well, you wonder. It looked kind of like there could have been impropriety, but, you know, nothing happened. Congress put in another law called Judicial Conduct and Disability Act. And this is a statute that people, as folks, can file complaints against federal judges. So if you have a complaint, there's a statute, and you can put it in. But, you know, you can't get rid of a judge, and you can't fine them, so. But it will be a mechanism for informing the leadership and the judiciary that there's some kind of problem. You know, maybe a judge, you know, sometimes they retire. You know, they don't always wait until death knocks. You know, and maybe they could be persuaded to retire. They do retire all the time. Now, there's another law by Congress that requires judges to disqualify themselves in a case where their impartiality might be questioned. This is the thing. The Supreme Court justices value their independence, but there are laws Congress has passed that do affect what they do. So Congress has said, if you have personal knowledge, like you know the people, you can't hear a case where your own family's in it, or where you have a financial interest, or you were involved in the case. This applies to all the justices. It seems to apply to the Supreme Court, but they would refuse to admit that. Then this is the one that gets the most play, Ethics in Government Act. Another act by Congress. It's the financial reporting. Report your outside income, your outside employment, any gifts you get. It doesn't apply to just the courts. It applies to all the top federal officials. You have to fill out this form. And it applies to the judges and the Supreme Court justices. Sometimes do give these reports, but they don't always. So another issue that comes up is called forum shopping or venue shopping or judge shopping, where you try to, if you're a lawyer for somebody, you pick a certain district where you think your case will get a favorable hearing. The most well-known that I remember reading about over the past couple of years. There was a district court in Texas where there was only one judge assigned. And so his views were known. And so, for example, he got the case where the plaintiffs, who were doctors, they said, the FDA approval of mephistoprone is defective, and therefore that product should be removed from the market. So they picked a court with one judge, and he said, yep, it's bad. He agreed with the plaintiffs. Oh my God, imagine that. Now, eventually that particular case got tossed out of the Supreme Court for lack of standing. It wasn't a real case yet. The doctors had argued, well, we might get a case where one of our patients has somehow gotten one of these drugs, and then she might take it, and then she might have a bad reaction, and I'll be stuck trying to care for her. And they said, not really a case, more like an advisory opinion. Now, the Judicial Conference, the committee, they have put some rules in place to try to prevent that from happening, the judge shopping. Now, in Minnesota, we're just one district, and the cases are assigned randomly. So you put your paperwork in, and they just, you get what judge you get. You can't really pick. The league was also interested in what they call judicial representation. This would be a sense that all the groups in the society of sufficient size should see one of their own on the court. So this is, I hesitate to use the word diversity. It's sort of coming out of favor again, but until 1972, judges, where they came from was very important to the executive branch. You wanted to have people from the area. You wanted to have Southerners in Southern seats. And when you get to the Supreme Court, you want to have some diversity, but based on region. And since, before 1925, since they had to ride circuit, it was important to be from an area because you had to know the back roads and the front roads, and when you were riding, you would be familiar with the states. Now, the religious diversity. My reading that says from 1916 to 1969, there was always one Jewish seat. Just a nod. Today, of course, there are no Protestants on the court. It's only Catholics and Jewish people. Now, the founders would have been, gobsmacked because most American governmental branches for the first 200 years were, white Anglo-Saxon Protestant people, men mostly. So today, it's completely different, and I don't know if it's important or not. It's just, this is the way the appointments have gone. On the racial diversity, since '67, they always had room for one black person. And that was true until 2022. And now, I don't know, is it important? Is it not important? I don't know. Gender diversity. 1981 was the first female justice. And then we've gotten, 5 more over the years. So, I don't know, is that important? It might be. Sexual orientation. There was one justice who was believed to be a gay man, but not openly, but everybody who knew, knew that's. But so it hasn't, nobody's looking around today, and I don't know what kind of, if any of these diversity characteristics, are any of them important? But, when people look at the court, if they seem to be different kinds of people from different walks of life, maybe that conveys confidence or legitimacy. It doesn't look like a club that only a few people can get in. But the club has some new rules. Uh-oh. So there's been complaints about the court, especially on the whether or not there's a real code of conduct that applies, whether they disclose their gifts. A lot of their decisions have been very, very consequential. Very consequential. So there are proposals out there to change the Supreme Court. You could increase the number away from 9. Congress can do that. If they, Franklin Roosevelt, he proposed to do that in the 30s because he was aggravated because they kept throwing out the New Deal legislation that he thought was necessary to counter the effects of the Great Depression. And it was never enacted. But oddly enough, the justices, of course, began to change their tune, and they began to uphold the New Deal legislation. So they never did this, and this is always, this is typically called court packing. It's negative. Increasing the size of the Supreme Court is viewed as negative. There have been 2 proposals for term limits. One is amend the Constitution so that you don't have this life tenure for federal judges. And there have also been some statutory ideas. Now, whether the Supreme Court would find that constitutional, well, I don't know. And I offer no opinion. You could add another layer of court. We could have a district court, then the circuit court of appeal, and then have the intercircuit tribunal that could take some of these cases, and then have the Supreme Court at the top. This, I found very little on this. It's not discussed. I'm not sure what the motivation would be to reduce the caseload of the Supreme Court. Well, they can do that themselves. But here's, Congress could change the jurisdiction. They could change the kinds of cases that come before the Supreme Court. We saw that in the very beginning. Congress decides the kinds of cases that they can hear. So they could, if they felt like it, actually tinker with the jurisdiction, appellate jurisdiction. They could say, well, no more appeals under the so-and-so statute. They could do that. I mean, that would put a monkey wrench into a lot of people's thinking, but it's in the Constitution. Congress could challenge the court's authority to regulate itself. I mean, they've got laws on the books, you know, but they don't, to date, take any action. Now, you know, there are certain people in Congress, Senator Sheldon Whitehouse would be the big example. I mean, he's on this, you know, that's his mission, one of his missions, you know, to impose ethics standards on the Supreme Court justices. But, you know, he's just one out of 100. But, you know, but it's up to Congress to decide, are they gonna push the Supreme Court or not? It's up to them. But there is some room. There is some room. Oh, one other, I was going to add a slide and I forgot to do that in time. So Rita Mills did my PowerPoint for me, and she's very, very generous and gracious. But so this whole program is only about Article 3 judges. The Supreme Court, Circuit Courts of Appeal, District Court. But there are a lot of other judges out there, and there's two groups, which you read about in the paper all the time. One are the asylum judges. There's, I don't know, hundreds of them. They hear asylum cases. They're not Article 3 judges. They're employees of the Department of Justice. And their new boss is Pam Bondi. So I guess they'll be implementing the whatever philosophy, you know, her department wishes. The other judges you hear about are bankruptcy judges. If you want to file bankruptcy, you have to go to the district court. You can't go to state court. It's a federal thing. But those judges are not Article 3 judges. They are appointed by the Circuit Court of Appeals, and they have a term of 14 years. So there's plenty of other judges out there that are not Article 3. So they have term limits, or they could be fired, you know. So, but this is a, you know, relatively small group. Oof, done. So that was my last slide. But I'm happy to take a few
Yeah, if
questions.
anyone would like to, I'll run around and hand out some cards, and then I'll read them into the microphone so that we can all hear the question. Who else would? Thanks. Okay. Anyone else? Okay. Oh, we got a lot of questions. Thank you.
Do you want to expand?
And while you're writing your
Advance to the end.
questions, I'll thank Karen. I learned a lot from you. And what an important topic, right? What an important topic. So, question. This is sort of a little diagram. I'm not sure what the question is.
I do.
Okay.
It's a question that came up at our program last month. And the question is, well, what is the difference between a judge and a justice? Because when we talk about the Supreme Court, we talk to them as the justice. It used to be Mr. Justice, but then when Sandra came on, they had the O. So now it's just justice. And all the others are called judge, as in here comes the judge. So I learned from a friend that it's a holdover from English common law, that somebody who decides a case is a judge. But at the end of the line, at the highest one, you're supposed to get not just a decision, you're supposed to get justice. And so, this friend of mine is a learned attorney, and I believe him. Okay. What percentage of cases are appealed from district court to circuit and from circuit to Supreme? There are 400,000 cases a year when you add up all the districts. And for the number that get to the Supreme Court on a merit basis, 50, 60. So the truth is not that many, not that many. And most people, it's expensive, right? One interesting thing about the shadow docket, though, where it came from. Why do they make decisions at night? Why don't they sign them? It started out with the death penalty cases. Those are emergencies. When they give the order, your execution date is. So there were a lot of emergencies. Now Congress then, over the years, reduced the appeal rights of most death row inmates. So they to get rid of this river of cases. And so they don't have that many, but that's where it came from. Because those are emergencies. Can you comment on the role of the Senate to delay or rush the approval? Is it optional or a duty? They control their own calendar, and so they do as they wish. There's nothing in the Constitution that talks about how close is the election or anything like that. It's just up to the Senate. If the president can nominate somebody, get somebody, in the door, they can be approved in a day, which we have seen. Any idea what the league is hoping to learn with the study? Yes. They wish to have league members weigh in on the values side of it. Their questions deal with transparency, accountability, independence, ethics, standards of conduct, court hearings and documents available to the public. There should be an enforcement mechanism for the Federal Judiciary Code of Ethics at all levels. So they're talking about enforcement of ethics rules. A judge's decision to recuse or not recuse. I must have forgotten my slide on that. Judges, there is a law, Congress says you have to recuse. You have to sit it out if you've been in the case before, or you know the people, or you're invested in that company. So the league wants its members to talk about recusal. Now, judges do recuse, but they don't put it in writing. They just recuse. There's no requirement that they write down why they recuse. Is that a good idea? Well, I don't know. And then the league is interested in financial disclosure, disclosure of income and gifts, book deals. I mean, you know, Clarence Thomas has taken quite a few hits for the gifts he's received and kind of finally getting around to disclosing them. But it's, you know, the others, there's people have pretty big book deals, you know, so it's not just Clarence Thomas is the problem. You know, it's actually, it can be across the board. The other thing that the league is interested in is stability of the law. You know, not having the law change too fast. So that's why I mentioned the Texas heartbeat case. You know, boom, all of a sudden abortion's illegal in Texas. I guess that's a big change. And of course, then they did, you know, change. They did overrule Roe v. Wade, you know, but, which is probably why they let that heartbeat law go into effect, because they knew what they were going to do. So those are the types of questions that the League of Women Voters US, the mothership, wants us to think about.
Couple of shorter questions.
What happens to cases the Supreme Court justices don't choose to hear? That means that whatever court was the last one to rule, that's it. So if you have a case here in the District of Minnesota, and then you take it to the 8th Circuit Court of Appeals, and the Supreme Court doesn't look at whatever the 8th Circuit did, that's it. Is only a simple majority required to issue an order via the shadow docket? Yes, there has to be a majority of voting for it. So, but that's by their own rule.
Thank you once again. And I encourage all of you to browse our materials. Look on the wall. We have some really cool events coming up in March and April. And thank you for joining us. And once again, thank you, Karen.